As Busai already mentioned, today we are going to be looking at Bill of Laden. My name has already been mentioned. Success Etim is my name, and I'll be the one taking this class today. Please note that we are all learning. That I'm the one speaking doesn't mean that I know everything. So I'm going to be expecting that we'll share knowledge together, and I hope that at the end of the session, I would leave here better than I joined. Please feel free to contribute, to ask questions. Initially, just to mention on a lighter note. Okay, so what are we looking at today? We are trying to see, to provide us with an understanding of Bill of Laden and Letter of Indemnity. As Afolabi mentioned, this is a law question that comes out from OW to Chief Met and to the master's level. This is one question that you can play with. I don't see it as a pass or fail question, but I see it as a very good question that you can use to, one of the technique in orals is, like a time wasting or time delay where you can, just focus on your strength and then just continue talking. This is one of those questions where you can do that, unlike rules of the road or voyage where there's nothing you can really say that apart from giving an answer to what you've been asked. So with questions like this, you can, just go out there and just tell the examiner what you know. Spend as much time as you want until the examiner tells you to stop. But just take note that you don't dig a grave for yourself to go and speak about something you are not so sure about. So our objectives at the end of the session is to discuss the purpose and function of Bill of Laden, differentiate between Bill of Laden, Met's receipt, and seaway bill, and then discuss the use of letter of indemnity. Okay, so to start with, I'll just ask any volunteer on the call to just tell us what he understands by Bill of Laden. If there is a volunteer, what do you understand by Bill of Laden? So if an examiner asked you, what is Bill of Laden? Whether you read about it, you were expecting the question or not, what would you say? Any volunteer? Okay. So since there's no volunteer. All right, so what is Bill of Laden? It's a document made out between the carrier and the shipper, and is proof of the contract of carriage. It's as simple as that. It's just a document that the carrier is going to give to the shipper. So I bring something to ship from Southampton to Nigeria, or from Nigeria to Ghana, or wherever in the world. And then as proof that I brought that thing and that the ship is going to carry it, the ship is going to issue me with a Bill of Laden. The Bill of Laden serves a lot of purposes, which we are going to be looking at. But in a nutshell, this is what you should be able to say about Bill of Laden. It's a document that is entered between two parties, the carrier and the shipper, as proof that the carrier has accepted your cargo to be carried from the point of receipt to the destination, which will be stated on the Bill of Laden. It's as simple as that. That's the Bill of Laden. So there are three primary functions that the Bill of Laden serves, and this is very, very key. It is very important. As I mentioned earlier, you can use this topic to just keep talking until the examiner says to you, stop. In orals, an examiner can't keep you more than a certain amount of time, yeah? So if you know something, hold on to it and just let him be the one to tell you it's enough. It's a good way to show that at least you know something, and it can compensate if you've missed some other little things. So these three primary functions of the bill of lading is very key. It is very important that we know them. So again, I'm going to ask if we have a volunteer in the room. I believe somehow we must have heard of bill of lading. There are three purposes that bill of lading serves. What are those three things? Even if it's one that anybody can mention, I will be happy with that. Do we have any volunteer that would tell us about the primary function? Even in the definition, it is there. Do we have any volunteer that would tell us about the functions of the bill of lading?
You can call names, sir.
No, I wasn't planning to put anybody on the spot, but I think maybe that I'm being tempted to put people on the spot. Any volunteer? Okay, no problem. It's not a problem. That's the first thing. As I said, it is in the definition. If you can remember the three functions, even if, so there is no like correct way of defining bill of lading. If you can just remember the three primary functions that the bill of lading serves, you can just coin words out of them. So what is a bill of lading? It is a contract between two parties, carrier and the shipper, that proves that the cargo will be carried from point of receipt to point of delivery. That's receipt of cargo. So it goes to a bill of lading, shows and proves that the cargo that I, Success, wants to ship to Afolabi has been accepted by the carrier. So it's a receipt of goods from the carrier. It shows a receipt of goods from the carrier that goods have been accepted on board. Now, there is another thing when we were looking at our objectives that I mentioned about met receipt. Met receipt also shows that we have received, there is a cargo on board my ship, but it's different from a bill of lading. So if we have to dig deeper, the bill of lading indicates that the cargo has been received by the carrier on board, which is just what I've been blabbing all along. It also indicates the condition in which the item was received. So yes, I've received your cargo on board. Take, for example, steel rods. So I've received steel rods from Afolabi, but the steel rods are rusty. Now, if I don't indicate this on a bill of lading to show that I received rods with 50% rust, by the time it goes to the discharge port, I can be sued for liability for improper carriage of the cargo which was delivered to me. So it is my job to indicate what condition that the goods had when I received it. So if the item was defective on receipt, this will be claused on the bill of lading. We'll come to that clausing later. It will be termed as dirty. So there's what we call a dirty bill of lading. So we have a clean bill of lading. A clean bill of lading is a normal bill of lading that everything is okay. I issue you a bill of lading. But when it is claused to say something was wrong or something is missing, then that is a dirty bill of lading, and it has implications. So similarly, goods received without defects will receive a clean bill of lading. So we are talking about the quality, the quantity of the cargo, the condition. Note that as a receipt of goods, it has legal importance for cargo damage, which I've already talked about. So there is a level of litigation. You can be sued for carrying goods in an improper way, or you damaged goods. Imagine that I bought a yacht and I want to ship the yacht from Spain to Nigeria. And along the way, or when the yacht arrived in Nigeria, I noticed that it's cracked or it has broken into two. I can sue the carrier. But imagine that the carrier received it as a broken yacht on board his vessel. So he needs to indicate that it was received damaged. So that's for the receipt of goods. The next thing is evidence of carriage. So it proves that the carrier has accepted to carry that cargo from point A to point B. Again, I mentioned, if you look at the definition, it is the contract of carriage. So it is the contract between two parties that one party has accepted to carry a certain cargo from that point he received it to the point where he has been instructed to take it to. So let's look at this evidence of carriage contract. I'm just hoping that I'm not going too fast, and I'm hoping that everybody is understanding me.
We are, sir.
Okay, so evidence of carriage contract. Although the bill of lading is not an actual contract, it provides evidence that there is an agreement between the carrier and the shipper. So when I have my bill of lading in my hand, I know most people on this call might be shipping cars from US or from Canada to Nigeria a lot. You need a bill of lading from your agent in that country to tell you, oh, your car has been shipped. Here's the bill of lading. And then they go to DHL and post it to you. And you ask yourself, why do they need to do that? And then when it comes to Nigeria, for you to be able to claim your car, you need to provide that bill of lading that your agent mailed to you. Yeah. So it's an evidence of carriage. So if I come to you and say that I have shipped a car to you, and then I cannot prove it by showing you a bill of lading, then you should suspect that something might be wrong, except there is something else I did, which we will come to later in the course. So we've looked at the receipt of goods, we've looked at evidence of carriage, and then the last one is document of title. So why is it a document of title? As a document of title, the goods stated on the bill of lading are tradable. So in the oil sector, you load crude oil from Nigeria, and the crude oil is supposed to be going to Mexico. Once that crude oil leaves Nigeria, I am the shipper. I can go to the market and say, look, I have 100 tons of crude oil on board ABC tanker. I want to sell it. And then Captain Afolabi can say, okay, yes, I'm going to buy it from you. And $100 to Afolabi. Afolabi turns around and say, oh, now crude price oil has gone up. When I bought it, it was $1. Now it is $1.50. I want to sell. So he goes to the market again and say, I want to sell this 100 tons of crude oil. And then Felix comes around and say, yes, I'll buy it for $1.60 or $1.70. So Afolabi has made profits. The ship is still at sea. So you are carrying out transactions based on a cargo that you haven't even seen because of the document of title which is in your hand. So it allows you to trade the cargo even before the cargo arrives at the port of delivery. So it's also transferable. So apart from selling it, I can transfer the cargo to Afolabi. It doesn't have to be tradable. I can also transfer it to him from one person to another while the vessel is still at sea. Also, as a document of title, it has some financial implications, because when I go to the bank and I want to tell the bank that, yeah, I have this cargo that is coming, I need to get payment for it, the bank will ask me for the bill of lading. We are going to look at it in other slides. So those are the three primary functions of a bill of lading, which is very important and very key during an oral questions. As I mentioned, if you forget the definition, just think about the three primary functions. Now, if you notice that I have put the first words of the functions in red. So you know, when you are preparing for orals, one trick is always to get abbreviations for things. How do you remember them easily? So it's obvious. Now I need somebody to tell me, how would you remember this? They are all in red.
Red.
Exactly, thank you. So if you forget it, just think about the color red. So R, receipt of goods, evidence of carriage, document of title. So I've just color-coded them just to make it easy. If you forget it, what is bill of lading? Just think about red. If you can remember red, if you can't remember anything, even if it's one of them, evidence of carriage, you can make a definition for bill of lading out of that. Document of title, you can make a definition out of that to an examiner. Just tell him it's a document that proves that the cargo can be traded from one person to another or transferable even before the cargo reaches its final destination. Okay, so moving on. We talked about clean and dirty bill of lading. Sometimes it's called a closed bill of lading. Yeah. So what is this? Let's start with the clean bill of lading. So clean bill of lading means goods received without defects. It has legal importance in case of litigation, which I mentioned earlier. So if I'm being sued or if I'm suing someone, I need the bill of lading as proof that when I gave Captain Afolabi these goods, as at the time it got on board the vessel, it was in good shape, it had a cover, or the weight was okay, but when he brought it back, so I shipped coal, and then when the coal came, the coal is less than what I had shipped, you know. So I have proof of that on the bill of lading. So it has a legal importance in case of any litigation. Last one is that it supports letter of credit from financial institution, which I talked about earlier. So you can use this to get a letter of credit from the bank. But if your bill of lading is closed or it is a dirty bill of lading, no financial institution would answer you except something else happened. And that's where we'll now be talking about the LOI, which we'll come to later. That's the letter of indemnity. So those are the three things you should consider, or the three top ones that comes to mind. There are other things you can say about a clean bill of lading, but just to keep it simple, I just put three things there. It supports credit from financial institution, is important in case of any litigation, and that means the document is acceptable as evidence in the court of law, yeah? And then it's also a proof that goods were received without defects. So dirty bill of lading then. Defects or inconsistencies noticed. Say, for example, you brought me a cargo that does not have a cover, or something is broken. The cargo is wet or is stained, maybe has stained cartons, insufficient strength to the crates that the cargo is on, unprotected machinery, you know, second-hand cases, rusty steels, which I gave as an example earlier, dented drums, and so on. Sometimes an examiner might not come out outrightly to ask you what is bill of lading. At OW level, they might, but by the time you get to chief mate and the master's level, he can just create a scenario for you, telling you about a cargo that was brought that has some inconsistencies. He might couch it any way he wants. An example is that story I made about rusty steels. A cargo is delivered to you, and the steels, you've noticed that they are rusty. How would you go about loading it on your vessel? He is not asking you, tell me about bill of lading, but bill of lading can help you answer his question, you know. Okay, second thing, in such cases where there are inconsistencies with what the shipper declared and what you have noticed, Bill of lading must show the nature of the damage or such comments. So the comment is the clause as may be appropriate. So depending on what has happened, you need to state it there on the bill of lading. Once you close a bill of lading, it is no longer clean. It becomes a dirty bill of lading. Agents don't like it. People generally don't like it. And one of the first reasons you should think of is the credit from financial institution. A dirty bill of lading will not support that credit. People would not want to trade a dirty bill of lading because they on the spot know that something is wrong with that cargo. Yeah. So that is the reason people don't like a closed bill of lading. So they always try to lobby or persuade the master, oh, just issue me a clean bill of lading. I will indemnify you. I will give you a letter of indemnity to say in case anything happens, it's on me. But we'll come to that. So let me not just jump ahead of myself. The next thing is, it has credit implication as bill of lading no longer evidences shipment in. So in every bill of lading, in every clean bill of lading, there is always the quotation that the shipment has been carried in apparent good order and condition. So the moment you have noticed something, that apparent good order and condition is automatically deleted. And financial institutions will not answer you because of that statement. That as little, how many words? 5 words or 6 words, thereabout. They will not answer you. So it has credit implications when it comes to proving, using it as evidence of shipment. Any question to this point? Okay, so I tried to list some content of bill of lading. If you go online and just type bill of lading and click images, you should see a picture of it. But I think on the next slide, there is a picture of one that I found. But just some things that are just there on the bill of lading, which might interest us to know. So the way I think about this is, if one asks you, for example, I've never heard of an examiner asking, but who knows what you might get or what any of us can get. But if someone was to ask me this question and I do not know, common sense is allowed. I will get to a place where I would tell you about a question I was asked and I didn't know the answer, and I will tell you how I answered that question. So if someone should ask me, can you tell me some contents that are there on the bill of lading? And maybe I've forgotten, can't remember, or I don't know at all. I'll just think about, I believe all of us, we've shipped something at one point or the other with DHL. So what is there on your DHL shipment? What do you have? I would believe you have a date. If the DHL guy comes to your gate, I believe he would ask you to sign, so there should be a signature. I would believe that I would see the name of the person who sent it to me and my own name as the receiver. So little things like that would help you answer that question without just sitting down and saying, oh, I don't know. You know, just don't overthink it. Just tell him what you know, yeah? So we have bill of lading number, reference number, who shipped it to you or who is shipping, who is the consignee, vessel name, that's the carrier now, port of loading. So if you can remember port of loading, what should be the next thing on your mind? Port of discharge, yeah? So where is it leaving and where is it going to, or where is it supposed to go to? Port of discharge. Description of the goods, which we have talked about, shipped in apparent good order. It will have to show some qualities. What is the weight of the cargo that is being carried? What is the quantity, depending on the type of cargo? What is the quantity? If there are steel rods, how many are there? You know, stuff like that. So description of the goods that is being carried. The dates, which I talked about. Signatures of the master or agent acting on behalf of the vessel owner. So those are just few, not all of them, but these are few things that you should be able to mention if one asks you about bill of lading. The simple ones here are port of loading and port of discharge. Shipper, consignee, vessel name, description of goods, date, signatures, bill of lading number and reference number if you remember, sorry. Okay, moving on to the next slide. So I said there was a picture here just showing an example of a bill of lading. So you would see what was shipped, computer parts, you know, the weight is there. You would see the number, bill of lading number. If you look towards the bottom right, you will see the bill of lading number. There is a place for date. You will see the consignee. You will see the shipper. So you see all those things that are there. This is just a typical bill of lading. I just found it online. So if you go online, you should be able to see it. It's not a big deal. Okay, how does met receipt and seaway bill differ from bill of lading? So someone once asked me, an examiner once asked me, he didn't even say, tell me about seaway bill. He just said, tell me about way bill. I've never heard of way bill in my life, apart from DHL. And I just told him what I knew about DHL way bill. I said, as I mentioned, don't overthink some questions. This is not like a pass or fail kind of question, except maybe it's at master's level or chief mate. And then the examiner might just look at you and say, this guy, you're not ready to captain a ship. But don't overthink something. If you know something that is similar, that can help you answer your question, just tell him what you know. So somebody asked me, what is way bill? That was the only question. How did I answer the question? I just talked about, okay, what is the difference between bill of lading and way bill? They didn't say see way bill, just difference between bill of lading and way bill. So I just went through all I knew about bill of lading, and then about way bill. I went off a bit by saying that, oh, it's not admissible in the court of law. I just, is like saying what's an opposite. So I said, way bill is evidence of carriage. Bill of lading does not necessarily prove. I just talked my way through it. I wasn't correct, but I just said something. That's the story I wanted to share. So what is met receipt? What is seaway bill? Why is it different from bill of lading? How are they different? So let's start with met receipt. So when a cargo comes on board, the first thing that would happen is that the chief mate or the cargo officer goes about and check, okay, what came on board, and then he documents them. Excuse me. He documents what came on board, and then he presents that to the master. Remember that bill of lading is issued by the master or the agent of the vessel. It is from the mate's receipt that the bill of lading is drafted from. So a mate's receipt can confirm that I received your cargo, but it doesn't prove that I will carry it. That is one of the difference. So I received it, yes, it's on board my vessel now, but it doesn't mean that by the time I'm selling out, that cargo will be on my vessel for one reason or the other. Maybe there is a dispute between the shipper and the agent. I can drop that cargo. So that is on the mate's receipt doesn't prove anything, yeah? But when you get a bill of lading about that cargo you want to ship, you are sure that the ship has agreed to carry it. So let's see. So mate's receipt is a document issued by the cargo officer as evidence of receiving cargo on board after verification of quantity and the condition. Remember, on the bill of lading, they would also put the condition and the quantity there. But mate's receipt is not a proof that I will carry that cargo. It does not guarantee cargo will be carried. Master stroke agent uses the mate's receipt to issue bill of lading. it is not a legal requirement. Therefore, it is not binding. Met receipt is just a procedural thing that we do. It makes life easy. It is adopted in the shipping community and people just do it. But it is not a legal requirement, so it is not binding. You can't take me to court and say, yeah, I have met receipt saying that my cargo is on board. Yes, but you don't have a bill of lading, which is a contract between me and you saying that I will carry it. Okay, I'm just trying to look at my time. So cannot replace bill of lading. So you can't take met receipt and run away and say, yeah, my cargo has been loaded. It's going to the country or the destination that I want. You need to wait and get the bill of lading. Now, going to seaway bill. So what is seaway bill? Does anybody know? Can anybody help? Does anybody want to mumble some words as I did? Any contribution about seaway bill? Let me check how many people are on this call. Okay, there are people here, so I'm not talking to myself and Felix alone. Okay, good. Good, good, good. All right. I'll carry on. So seaway bill is very similar to bill of lading in many aspects. It is very similar. I'll give you an example, which is in my slide. You will see it, but let's talk about it. So think about it. So bill of lading is proof of carriage, right? I can sell the cargo while the cargo is still at sea, correct? Yes. Now, we are aware that Toyota just opened an assembly point in Ghana, correct? Yes. Okay. Do you think, this is a question now, it's a simple question, it's a yes or no answer. If you were Toyota and you are shipping your parts, so you need to assemble cars in Ghana, but there are no parts in Ghana. So you need the engine, you need the metals, the doors, the stereo, all the parts of a car, tires, wheels, and you want to ship them from Japan to Ghana. As the MD or GM or whatever position you are holding, the man in charge of shipping in Toyota, do you need, knowing what a bill of lading is, do you need a bill of lading to do that transaction? Yes or no? And why? If you can tell me. It's a simple question. It's not a trick question. You know, you now know what a bill of lading is. Receipt of goods, evidence of carriage, and document of title. And we know what these three things are. And you are shipping, so where it is going to, it is you receiving it. Where you are shipping from, it is your own. You are not planning to sell it on the way. You are not trying to go and get money from the bank. Do you think a bill of lading is necessary? Yes or no? I think the answer, we should agree that is no. I don't think we need a bill of lading to do that transaction. Why? Because it is an in-house thing. It doesn't involve a third party. So Toyota is shipping, Toyota is receiving. There's no transaction that will be going on that the parts are, except maybe you are a Yahoo person inside the Toyota, and then you are trying to play a smartphone. Then you say, I have bill of lading. Who wants to buy Toyota spare parts? So except you want to do that, you don't need a bill of lading. If you don't remember anything about seaway bill, just remember that example. If you know that example, you can talk about a seaway bill. So seaway bill is similar to bill of lading, but it's just a document that you collect from the ship to show that you've shipped something to yourself. So you are shipping from Japan to Ghana. You are the shipper. You are the consignee. So you receive, you are the shipper. Another example is Microsoft. Imagine that Microsoft is shipping their products from one country to another. They're not planning to sell it along the way. They are the ones shipping it. They'll be the ones to receive it. There's no need for proof of, for a bill of lading for that transaction, because they don't need, so A seaway bill can serve as a receipt of carriage. Yeah, it can. It can serve as evidence of that agreement. But document of title, you are not selling it on the road, so you don't need to prove a document of title and go about selling it or run to a financial institution to get money. Yeah, so it's very similar. Fundamental difference is that way bills are non-negotiable, which is what I'm talking about. You can't sell it. So that example I made about me and Afolabi, you know, I sell to him and then he sells to someone else. We can't do that with a seaway bill. I cannot transfer it. So once they have put the name Microsoft, it means it is going from Microsoft to Microsoft. Along the way, I cannot say, no, I don't want to send it to Microsoft, send it to B&M or any other, IBM, sorry. Send it to, iPhone or Samsung or something else. So it's used especially when there is no need for letter of credit or no intention by the consignee to sell the cargo. So you are not planning to sell it. You are not planning to go and apply for a letter of credit from bank to show that you have money. It's just an in-house arrangement between yourself. So that's what a seaway bill is. I've talked about the practical example. When people or companies are shipping cargoes for themselves. So it's going from, I know the source that is coming from and I'm the one receiving it. I don't have to be afraid about, oh, this person can play me Ujoro, or this person can decide to be funny, you know. So an example is Toyota, which I mentioned. Another example is Microsoft, you know, just shipping their parts from one place to another. So that's the difference between waybill, met receipt, and seaway bill. So in case someone should ask you, you should be able to talk through them. If you remember what bill of lading is, you should be able to separate it from met receipt and seaway bill. Any questions? So I just put an eyes on the future. So currently,
I think somebody wants to ask a question.
Okay.
Is there any question from the house? Oh, okay, we can continue, sir.
All right.
Sorry, I want to ask a question, sir.
Yeah, go ahead.
Okay, like you know this mate receipts and this other last one,
seaway bill,
mate receipts and way bill. Yes, seaway bill. Now you talk about always when the shipper is the owner of the cargo and every other thing. So what I'm asking is that, is there any law binding that every goods must have a way bill, mate receipt, and a bill of lading at the same time?
Oh, no. So I'm just trying to differentiate them. It's not as if, so you are shipping something, we'll give you bill of lading, we give you met receipt, we now give you seaway bill. No. You don't even get a met receipt. A met receipt is not a document for the shipper. It's just a document that is kept on board. So notice that, okay, say let's make it a bit practical. Say for example, a container vessel, yeah? It's going to receive a lot of shipments, correct? Different containers, some containing cars, computers, different things, and shipped by different people, yeah? The met receipt is going to list all of them, yeah? That's what the met receipt would do. It's going to list all of them, that these are all the things that we have received from this port in Dubai. We have received all of these things from this port. And then the chief mate or the cargo officer transfers this met receipt to the master and said, master, this is what we have received on board. I have checked everything is okay, and yes, we can go ahead and carry them. From the met receipt, the master will now issue a bill of lading to the owner of the cargoes. Now, the reason for this bill of lading is because sometimes the shipper is not the owner of that cargo. So I am the one selling crude oil from Nigeria, but this crude, I'm the one shipping it, but it is not my crude oil. Yeah. So maybe I'm just an agent. Somebody hired me and said, I have 1,000 tons of crude oil that I want to ship out of Nigeria. I need you to facilitate it for me. So I now go, I'll look for a ship that can carry it. And then I put the crude oil on that ship. And I say, this crude oil is going to India, for example. Now, and at the port in India, there is somebody who is waiting to accept the cargo. There are implications. For example, if you take a cargo and reach a port and you don't see the bill of lading, you are not supposed to deliver that cargo. But it becomes a big problem. Like Afolabi said at the end, this is the law part of maritime or shipping, is shipping law. So there is a problem that now I can't drop this cargo because you have not provided a bill of lading. But if I don't deliver the cargo, I can't carry something else. So I'm just stuck with somebody's cargo and just sitting there and waiting for bill of lading to reach me. So the reason why you are collecting bill of lading is so that the other party can claim it. So you are not supposed to keep the bill of lading. When you collect the bill of lading, you are supposed to post it out to somebody, to whoever is going to receive it. On presenting the bill of lading, the master can deliver the cargo to that person. It's different from met receipt. Met receipt, as we mentioned in the point 4, is not a legal requirement. It's just something we do on board. Some ships don't even call it met receipt. I've forgotten the word that I'm looking for now. Captain Afolabi, what is this document that you have where everything is listed and that's what
Cargo
the custom
manifest.
checks? Yes, manifest. It's just like cargo manifest where the customs can check. Everything that you are carrying is there. So it's similar to that. Some vessels don't call it a met receipt. It's just a cargo manifest. Master, this is what we have carried. From there, he can issue the bill of lading. It's very different from seaway bill, where you know who is shipping and the person who is receiving it. You are not going to trade it while it's on the way. That's just the difference. So you don't get the three of them at the same time. You will either get a seaway bill or you will get a bill of lading. I hope that clarifies.
Yeah, very, very clear, sir. And sorry that I'm wasting the time.
Not a problem.
Sometimes, yes, sometimes I receive, okay, when I want to buy a car, you know, the agent just give me some document and say, this is the bill of lading. You understand now? He just present the paper to me. Grab what I'm saying now. And everything contain what a normal bill of lading is supposed to be contained. And you and I know that from time to time, we always have people that fraud people, and they will still present bill of lading, just like we have our. So check the authenticity of a bill of lading to show that this bill of lading is original, it's not fake.
Yeah, I agree with what you're saying. You are very, very correct, and you just took the word out of my mouth. Eyes on the future. That's why I put it there. So with bill of lading, in some companies you can find these things. The agent, most times it's issued by the agent. So agent can just people do it a lot. You know, they defraud people, and if you search online, you will see cases. If you carry some maritime law books, you will see a lot of cases about them. They are there, they are evident. People do it a lot, yeah? So it's because, one of the reasons is because it's paper-based. So he needs to send you one paper and say that, okay, this is your bill of lading. Meanwhile, he hasn't shipped anything to you. And it could be fake, as you said. Now, how do you prove that it's original? The ship will have a copy of it. So when you present it, the ship will know whether this is the copy that was issued or not. So what did I put on Eyes of the Future? E-bill of lading or paperless bill of lading. That's the future of bill of lading. Some companies in-house have already started using it. Some terminals are already using it. So it must, it's always the reason why I said Eyes on the Future is that it's always good to know what is happening in a particular space. When you are studying some oral topics, always make sure you know what are the new laws that are coming into effect, when will they come into effect and all that. So there is a proposal to have the bill of lading become electronic because of maritime fraud. There is a lot of fraud going on. The second reason, there are many reasons, but the two topmost ones, number one is maritime fraud. Number two is because of the delay it takes for that. Imagine you are shipping something from Ghana to Nigeria. So you go to, maybe it's a Saturday or a Sunday, you go to DHL, before you post the bill of lading, before it will arrive Nigeria, the ship has bettered at Lagos. And then the ship is waiting for bill of lading, but it hasn't arrived. Not because you don't have it, but it has been stocked somewhere, maybe because of the weekend or something. So that's why they are proposing this electronic bill of lading, where everything is just done electronically and you can receive it directly either from the ship or something. Maybe they will just use emails or some portals. You can log in and download it. Just something is being done around that because of those two reasons. One is for fraud, and the second reason is because of the delay on receiving the bill of lading. So you are very correct in what you said. Okay, time is running out. So moving on to letter of indemnity. So this is the big one. So what is letter of indemnity? It acts as an unofficial form of insurance. Bottom line is it provides insurance in instances where a party is requested to step out of the bounds of its contracted obligations. So my obligation is that I'm supposed to move your cargo in good order. Remember that thing I highlighted. I'm supposed to ship it in apparent good order, but it is not in good order. So now I need to put clause that this thing Afolabi gave me is not in good order. But Afolabi doesn't want it because he needs a letter of credit from the bank. So how can we solve the problem? Afolabi will tell me, okay, master, look, I'm going to indemnify you to say that, okay, this rust, if by the time it arrives and there is rust and blah, 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 I am taking responsibility for it. In return, I need you to give me a clean bill of lading. Simply, that's what letter of indemnity is. Just you stepping out of, okay, I'm going to step out of my way to do something for you, but you need to give me a guarantee. Another example is, Afolabi asked me to deliver a cargo to India. That's crude oil I was talking about. Was supposed to go to India. While I was on my way, Afolabi said, no, I don't want it to go to India again. I want it to go to Kuwait. Maybe someone is buying it there more expensive. So I don't change your route, start going to Kuwait and deliver it for me there. On the bill of lading, it is clearly stated this cargo is going to India. So Afolabi needs to provide me a letter of indemnity, because if I go and deliver it in Kuwait and somebody is waiting for it in India, the person in India can sue me for wrong delivery of a cargo. So I need a letter to cover myself from that litigation in case it comes up. That's just what letter of indemnity is, trying to explain it. So let's quickly look at it. When can this be requested? It can be requested in different scenarios, but in preparing this, I just looked at maybe top 3, top 4 things that I wanted to share just to meet up with time. So where can this be requested? Where the cargo is required to be delivered to a place other than the port named on the bill of lading or to the charter party. So when there is a difference in what is on your bill of lading, you would need a letter of indemnity. Request to deliver at a different port to that named in the bill of lading. Where a claim bill of lading is requested in place of a rightfully claused one. So this, the third point should have been the first point. This is where the maximum number of letter of indemnity comes in. People don't like claused bill of lading because you can't even sell the cargo. So if I know that you are shipping rods and you are saying, oh, I have rods to sell, and I'm seeing bill of lading is claused, that means automatically it's a red flag for me. I know something is wrong with those rods that you are proposing to sell. So I won't buy it. I want to see it physically before I can bid to buy it, to know the exact condition in which it is. So again, it boils down to maritime fraud. So a lot of masters and agents get involved in this. Oh, issue me a clean bill of lading in place of a claused one so that I will give you letter of indemnity. And then they now present the clean bill of lading. Remember, with the clean bill of lading is tradable. So while the vessel is, on the sea, going to the port of destination, I say, yeah, I have a clean bill of lading of rods, 100 tons of rods. Somebody said, yes, I'll buy, and I sell it to the person, I collect the money, and off I go. And then it arrives the port, and then it is not as stated on the bill of lading, is not clean. And then the consignee, that's the receiver now, is saying, I'm going to sue you for delivering me something that is. And I said, I'm the master of this vessel. I have letter of indemnity against this thing. Okay, it's already 56. I'm so sorry I overshot your time. Okay, so there are inherent risk in accepting letter of indemnity. That is why it is not an advisable practice. It is done, it is part of the practices, but it is not like something that is encouraged, because people will start having issue with trusting your company. People will start having issue with the master and stuff like that. So what are the risks? The issuer stroke guarantor trustworthy. So if you are going to take it, do you trust the issuer of the letter of indemnity? Because the letter of the indemnity can say, yes, I can cover whatever cost. But is that issuer of the letter of indemnity or the guarantor of that LOI trustworthy? Do they have the money they claim to have? Can they cover the cost in case of anything? You need to look at that. The wordings may be deceitful. So again, remember, this is a law thing. So somebody will go and bring you a letter of indemnity, and then it's all, you just, what we do with, how many of us read terms and conditions? When you buy a new phone and they say, click this button if you accept terms and conditions, and you boom, accept. You don't check it because they are just law terms inside there. So you need to be careful with the wordings, because some fraudulent people would actually give you a bill of lading, but inside they would exempt themselves from any liability inside the letter of indemnity. So you need to be careful with the wordings, which can be deceitful. LOI may not be enforceable if illegal act is supported. So if it is noticed that you supported an illegal act, say for example, you gave a clean bill of lading for a cargo that wasn't clean, legally nobody is going to back you up. So you have to bear the cross for that actions. So basically it has impact on a company's reputation, or the agent or the master. It has credibility issues, and people may not want to do business with you in the future. It has serious litigation issues. You might be sued even with your letter of indemnity. And if the party that guaranteed it cannot prove to pay it, again, you are putting your vessel owner at risk of being sued for something that in the first place shouldn't have happened. So if you have an opportunity or a case like this presents itself, if the bill of lading needs to be claused, you go ahead and clause it. Do not necessarily accept a letter of indemnity. The places where you can even think of accepting it is if they are saying deliver to a different port, or maybe to a different charter party. So I think I've come to the end of my presentation, and I hope that we all learned one or two things, and we'll be able to remember one or two things from here in case someone asks us in the future. Thank you, and back to you, Captain Afolabi, and thanks for the opportunity.
Thank you very much, sir. We did not learn one or two things. We learned so much, to be honest. And one of the things I will not forget is the red. Red is receipt of goods, evidence of carriage of contracts, and then the documents of title. So when you go down to an exam, just remember red, and you'll be able to get that as well. But honestly, yeah, this might look like a brief topic, but I've looked at really questions that examiners are bringing out of the bill of lading, and most of the questions are really: what is bill of lading? What is LOI? When will you receive LOI? And when will you receive bill of lading? And Captain Etim have just tried to let us know that first spot should be bill of lading. Then the second one should be LOI, but the LOI should be still based on circumstances as well. So based on this, does anybody have any question on bill of lading or letter of indemnity? So JJ, when are we going to receive letter of indemnity? If I'm in the office and I'm forcing you to receive letter of indemnity, what will you do as the master?
Hello?
JJ, Felix, MJ, anyone? I'm the superintendent and I'm forcing you to receive a letter of indemnity.
Okay. Please go ahead with your question again, sir.
Yeah, so I'm in the office and I'm telling you receive a letter of indemnity, forget about the bill of lading, and let's go there. What are the first things that you're going to be considering? Are you going to just receive it or something like that?
Okay, you're asking me I should receive a letter of indemnity.
Yes, that's correct. I'm giving you an order as as your boss, and you are the master on board.
No, I will not receive it. I will not just receive it like that.
Okay, so what would be your reason?
There are a lot of risk involved in that, according to what our lecturer just talked about now, about letter of indemnity. Just like we have our terms and conditions that are written plenty, and you just see people just accept it. For the letter of indemnity, as I said, there are risks that are involved in it, because the terms and conditions involved in it might be some terms that will not favor me as the master of the vessel, that can put me into trouble.
Oh, okay. I will still come back to that answer. Felix and November Juliet, yes, no, and what will be your reason? You can unmute yourself and tell me.
With a clean bill of lading, which has of course has a legal backing, and one can receive a letter of indemnity.
No, I think you have to have a letter of indemnity, or you have to have a bill of lading. So if you are given a letter of indemnity, just like Captain Success is trying to let us know, please stick to your bill of lading. But also there are cases, just to round it up, there are cases where you have to come down to letter of indemnity, but you also have to look at the risks involved, just like JJ said as well. So with that, I really say that we should try and really look at, go in depth again into bill of lading. You have any questions, drop it on the group. But bill of lading and letter of indemnity are very, very important subjects on maritime law as well. With that, I want to say thank you again to Captain Success. Seriously, he always used to be my teacher many years ago, up to 11 years ago. And he's still a very great lecturer. It's a privilege to have you. And since so many of us, we are looking up to you, sir. Thank you again for your time this evening. Now, with that, thanks everyone. This video will be on YouTube. I myself will come back to watch this video because it's really very rich, to be honest, and it's a very clear explanation of Bill of Lading and letter of indemnity. Thank you.